Assalamualaikum and hi everyone. Our group will present about our topic, which is termination due to change of business ownership. First, my name is Siti Rasna. I will present about introduction. In context Malaysian employment law, change of ownership will take place when there is a sale of the actual trapping of the business as a going concern. An actual change of ownership situation will entail more than the mere transfer of the asset. Business can change hands in two ways. First, sell share to a new person means employee seamlessly become an employee of the new owner. An employee does not actually change because business not owned by a shareholder but by the company. Second, sell it asset to a new purchaser means employment will end on the date that the sale is finalized, means individuals are not commodities that can be bought and sold, which is the employment ends. Next, change of ownership also brings a changes that will affect to employee. This is because first it will change in management style. New owner may have a different management style. When a large company with a more structured organization acquires a small one, the changes could include employees having a deal with a significant number of new roles. Second is a reorganization. At all levels may be changed and even departmental or office duties may be reorganized. And third one is personal change. New owner will decide to reduce staff or bring in their own people in management or staff roles and replace those that occupied those in that position before. And under common law, contract of employment did not transfer automatically to a new employer when the business in which the employee served was transferred as a going concern. This was in accordance with the contractual principle that contracting parties may not assign their contractual right and obligation to a third party without the other contracting party's consent.
I'm Stephanie and I will present the next part, the employment impacts due to change in business ownership. So, due to the change in business ownership, it will affect both employees and employers. In terms of employees, changes in employment might occur and then it causes to termination. In terms of employer will give termination benefit or notice of termination. So if there is no notice of termination, therefore employer must pay a termination benefit to their employee. Next part, employees to be terminated at the first place. First one will be the foreign worker. According to section 60N, employer must terminate foreign employee before termination of local employee take place. And the second one will be the trade union member. Employer choose to terminate union member. The purpose is to limit the areas in an employment relationship where unions can be involved in and also the kind of industrial action that union can undertake to promote and protect workers' rights. Next one will be, so how employees are selected for termination. It is based from the LIFO principle. LIFO stands for last in, first out. It means junior employee based on the length of service to be terminated first. So there are several advantages of LIFO principle. The first one is to reduce possibility of favoritism, easy to administer, and rewards who have so far been loyal to the employer.
My name is Rafika and I will briefly explain more about the employment management in legal context. Okay, so the first one is the need to give notice. Whatever the situation, it is very important that employer have to give notice of termination of service to the employee, so the employee will be informed that the ownership will be changing. The need to give notice served according to the notice period in the contract of employment or by collective agreement or as provided under the section 12 sub 2 of the Act. If the shorter notice is being agreed in the contract of employment or collective agreement. This is the table of notice of termination of contract. For the 4 weeks notice is for the employee that has been worked less than 2 years, and then 6 weeks notice is for the employee for 2 years or more than 2 years but less than 5 years, and the last one is 8 weeks notice for the work experience more than 5 years.
Termination benefit payable. In changing of business ownership, within 7 days of change of it, offers to continue to employ an affected employee under terms and conditions not less favorable than those existing and with continuity of employment, the employee will not be entitled to any termination benefits payable under the Employment Regulation 1980 if they unreasonably refuse the offer. In addition, if the offer of continue to work, if the offer is not there or the offer does not comply with the above stipulation, the contract of employment shall be deemed to have terminated and the former employer will be liable for the payment of termination advantages. The right of an employee to termination benefit upon retrenchment depends whether or not he is covered by the Employment Act. An employee who falls within the scope of the Employment Act is entitled to termination benefits if he has been employed for at least a year or 12 months. The termination benefits payable are as follow, or the amount in the employment contract if it is higher. For the first to second years of service, 10 days wages for each year of service, and for more than 2 to 5 years, the payment will be 15 days wages for each year of service, and for more than 5 years, the payment would be 20 days wages for each year of service. For the employee that not covered under the Employment Act, they are only entitled to termination benefit if it is provided in his employment contract. But if the contract is silent, then it is up to the employer whether or not to pay termination benefits to them and how much the employer want to pay. This is one of the example case from the court decision. The case which is Rada versus Dunlop Estate Berhad. Dunlop Estate Berhad sold its estate to another company in 1990, and 359 affected employees were given continued employment with no loss in benefit and seniority by the new employer. The employees subsequently claimed that DEB failed to issue notice of termination to them as required by Section 12 sub 3 sub F under the EA. Labour Court and the High Court rejected the claim on the ground that there was no termination of service as the employees had accepted continued employment with the new employer. And then the court held that the employees had ceased to be employed by DEB on the date of change of ownership, and thus the termination had occurred. It ordered DEB to pay 231,490 ringgit and 16 cents as indemnity in lieu of notice of termination to the employees in accordance with Section 13 sub 1 under the EA.
Conclusion: terminating employees is one of the most unpleasant aspects of a business owner or manager job duties, but sometimes it is absolutely necessary in order to continue the business of the employer. But if terminating an employee is necessary when changes ownership in business, then it should be performed in the most ethical and professional manner possible. They must follow the proper protocol in conducting the termination softens the blow to terminate employee, who is very often surprised that they are being terminated, protects the business from
potential litigation arising from the termination, and reassures the owner or manager that they did the right things, whether the terminated employees was a good worker or a bad worker. It is irrelevant. Thank you.